Associate Professor Walter Theseira.
Mr. Deputy Speaker, thank you for the opportunity to speak on this bill. This bill will improve protections for all employees while balancing business costs and employability. The most significant improvement is the extension of core provisions of the Employment Act to managers and executives. We must be realistic. In an employment relationship, the employer often has more bargaining power. That is why unions exist, to balance the greater power of the employer. Now, managers and executives were formally excluded from the Act because we presumed that power was more equal at that level. That may have been true in the past when the vast majority of our workers were rank and file. But today, most of our M&Es are in a similar position to the rank and file. They cannot afford to use contract law to settle employment disputes, and they do not have the power to bargain over employment contract terms. They should be protected by the Employment Act, just as the rank and file already are. Sir, a good labour law must also ensure that workers are employable and businesses can thrive. There are concerns that this bill may increase labour market rigidity for M&Es and hence reduce economic efficiency. But the core provisions of the Employment Act, such as timely payment of salary, wrongful dismissal protection, mandatory annual leave, these are really basic labour rights. A business that cannot afford to grant these basic rights is expecting workers and society to pay for their poor business performance. More importantly, the way that we will resolve employment disputes for M&Es will in fact lower business costs. We rely on mediation, and if that fails, the Employment Claims Tribunal. With due respect to some honourable members, lawyers are not involved, and that greatly reduces costs for both sides. Mediation is effective. Sir, the Minister for Manpower said yesterday in a written reply to Dr. Intan that the Tripartite Alliance for Dispute Management and the Employment Claims Tribunal have successfully helped 90% of employees recover salary claims in full. An effective dispute resolution framework will greatly deter errant practices which will avoid disputes in the first place. Now, that said, I wish to outline two emerging labour issues that are not completely addressed by this bill. The first is how the self-employed are treated. The self-employed are exempt from the Employment Act because they are not subject to the direction of an employer. We have all engaged property agents, private tutors, taxi drivers. We cannot oversee and direct them in their work. We have no obligations to each other as an employer and an employee. But today, many self-employed workers are subject to control by a counterparty who directs their conditions of work. Now, consider the debate during yesterday's sitting on hawkers. Hawkers are self-employed, but they can only work if they sign contracts with landlords to rent their stalls. Some self-employed hawkers sign rental terms that directed long minimum operating hours and other conditions of work. Now, these are not labour contracts. They are business-to-business contracts. The hawker can hire someone else to keep their stall open. But that distinction does not matter to a hawker who cannot afford to hire an assistant. For them, it is like a labour contract. I was glad to hear that the Minister for the Environment and Water Resources will ensure that these contracts will be revised when necessary to safeguard the interests of hawkers. Now, in fact, technology and new business models have widened the scope for self-employment while also subjecting the self-employed to greater control. Let me give an example of how self-employment has expanded in scope. Now, today, if you want cleaning services, you can appoint a cleaning company, or you can use a platform which offers self-employed cleaners on the task-by-task basis. A cleaner who works for a company enjoys benefits under the EA. A self-employed cleaner contracted through a platform does not. Technology platforms have made it easier to contract directly with the self-employed. In the United States, the J.P. Morgan Chase Institute found that in June 2016, 0.5% of all adults sold labor through the online platform economy, up from practically 0% in 2012. This is just an estimate for 1 month. As of 2016, US adults, about 1.5% of all US adults, have sold labor through an online platform at least once. Now, Singapore is not far off. The ministry's handout just passed out before this debate shows that about 1 in 20 of the self-employed here are private hire drivers. All of these sell their labor through online platforms. Since about 10% of the workforce in Singapore are self-employed, we see that possibly at least 0.5% or more of our workforce is now selling labor through an online platform in Singapore. Now, technology also subjects the self-employed to greater control. For example, although private hire and taxi drivers are both self-employed, taxi drivers are not subject to much control. Taxi rental companies do not care what taxi drivers do as long as the rentals are paid. Now, on the other hand, private hire drivers are closely monitored by private hire platforms. The platforms control many aspects of work. Drivers must accept bookings or face penalties. Some platforms even promise drivers minimum earnings provided that they meet performance standards. So, there appears to be an increasing tendency for the self-employed to be subjected to direction and control. The self-employed are made to comply with incentives and penalties. There is no protection against the use of penalties, unlike the Employment Act, which prescribes allowable payroll deductions and penalties. In short, many contracting parties want to have all of the benefits of control over the self-employed, but none of the statutory responsibilities under the Employment Act. Of course, I would agree, these workers have signed these self-employment contracts willingly. But the point of the Employment Act is to give statutory rights to workers because their bargaining power is weak. Otherwise, there would be too much pressure on workers to willingly sign away their rights. In the landmark case of AutoCleans versus Belcher, Lord Clerk of the Supreme Court of the United Kingdom wrote, and I quote, "The relative bargaining power of the parties must be taken into account in deciding whether the terms of any written agreement in truth represent what was agreed. And the true agreement will often have to be gleaned from all the circumstances of the case, of which the written agreement is only a part. This may be described as a purposive approach to the problem." End quote. So the point is, a contracting party with power may subject a self-employed worker to the direction of an employer, but without giving them employment benefits. The worker will agree because they have no choice. We must have a policy to address this emerging problem of self-employment that also provides for legitimate business needs. Now, fortunately, I believe the government is acting on this. In a reply given yesterday to a parliamentary question I filed, the Minister for Manpower noted that the tripartite standard on contracting with self-employed persons was formed in March 2018 to better regulate this emerging area. I will ask the Minister if more clear directions can be set forth so that employers are not tempted to misclassify workers as self-employed as a means of evading the Employment Act. The second issue is how unfair employment practices are regulated. Workers must be confident that merit is what matters in the labor market and not their age, race, gender, or other personal characteristics. The government addresses unfair employment through the Tripartite Alliance for Fair Employment Practices, or TAFEP, rather than through the Employment Act. This allows flexibility to recognize the diversity of legitimate business practices in Singapore. But it may also give some the impression that we have no commitment to eliminating unfair practices. The Employment Act amendment will help by allowing the minister to make regulations on some undesirable employment practices. But, sir, I think it will also be useful if the minister will consider making public the records of cases dealt with by TAFEP so that the public can see that unfair practices are being addressed. I will also ask if the minister can direct that the Employment Claims Tribunal, in adjudicating cases, can take into account the employer's past behavior, including TAFEP cases. This is so that an employer who has repeatedly violated any of our labor standards would have a higher burden of proof in ECT cases. Mr. Deputy Speaker, I believe my concerns on self-employed persons and on unfair employment practices may be addressed by future amendments or by regulatory power. I strongly support the current EA amendment, which will extend protections to all workers while being cost-effective for businesses. Thank you.